I'll go ahead and get started again. Good morning. My name is Irv Condon, your probate judge for Charleston County. We learned through the pandemic that we can do these things virtually, and we got somebody from North Carolina here. I think the furthest I've ever had is Alaska. So anybody going to beat Alaska today? I don't know. Our objective today is really just to tell you about probate court. We get a lot of calls, people looking for the probation officer. We don't have much to do with that except for drug court. Tell you about our functions. We'll talk about estate planning for every family and a little bit on elder law and alcohol and drugs and mental illness affects all of our families. And we'll talk about the civil commitment process. We hope people go voluntarily, but if not, we have an involuntary process. And talk a little bit about guardianship and conservatorship and how to avoid that by the use of a healthcare power of attorney or business of power of attorney or trust for conservatorships. And little points to ponder and trivia. And here's just another way of looking at our topics. Probate court, we run from from estates to marriage licenses to some problem-solving courts to state administration. We try to the purpose of these seminars or to try to get educate people for the need to do their estate planning and get it in place. Here's an organizational chart just to let you know what's happening at Charleston County Probate Court. If we look over to the left, we'll see our estate division. We've got 5 estate clerks. So if you're ever probating an estate, you can look at the ending number and see who your estate clerk is. In the screen that just popped up, I'll show you how you can reach them directly without having to go through a switchboard. In our estate division, we do about 2,200 estates a year. At any one time, there's probably about 3,500 open. We got 5 estate clerks, so you can see they've got 600 or 700 open files at one time, and they just keep rotating through. Commitment and guardianship conservatorship division. Again, we do involuntary commitments, about 1,900 of those a year, and just trying to get our family members the help they need. Guardianship and conservatorship, this is one area we definitely want you to try to avoid probate court. Guardianship is of the person, and probate court has jurisdiction over adult guardianships. Family court has jurisdiction over minor guardianships. Conservatorship is of the money, and probate court has jurisdiction over minor and adult conservatorships. But we can avoid that by the use of a business power of attorney and or a trust. And we talked about civil commitments. If you get involved in the criminal justice system, we've got 4 problem-solving courts that I've started to help people get a second chance. And a happy area, we have marriage licenses, and we got a program called Love and live online virtual e-marriage application that I'll show you. We do about 7,000 marriage licenses a year. A lot of people like to come to Charleston to get married. And here's our court staff information. And Jamie will send all this information out to you. I grew up with a department store, Condon's, believing in customer service. So we try to, instead of having to go through a switchboard, you can get the person's direct dial number and call them, and also their cell number to get assistance with them, and their email address there. And we'll show you later, we have electronic filing in our state and GC division that can also assist you. We're located down at the Four Corners of Law in Charleston. That's meeting in Broad Street. The mayor's office is bottom left. Our state court with our state division is located on the bottom right. Federal courthouse is on the top right. And on the left there is the highest law of the church. Believe it or not, Ripley's, believe it or not, gave it the name the Four Corners of Law. And this is Mrs. Ripley. Met her. She's over in James Island, direct descendant of Robert Ripley. So threw her picture in. Then and now, it used to be the state capitol before it moved to Columbia. And it was done by an Irish architect on the right there, James Hoban. He did our courthouse. President Washington in 1791 visited our city, liked the work he did, and had him bid on the White House, he ended up doing the White House. So a Charleston architect is the architect of the White House. He modeled it, for those that are Irish, behind Oban is a portrait of the Dublin Parliament building, the Leinster House. He modeled it after that. On the left there, we're dedicating a monument in his hometown. That's my son on the left there with the plaid pants. Our luggage didn't make it, and to buy some pants, and he's not sure what to do with the Irish girl there, but we just wanted to recognize James Hogan. All right, some trivia. What's the highest basketball court? We got some North Carolina people on here. They got to be, are you Tar Heels or Wolfpack? I don't know.
Go Pack.
Go Pack. Okay. I got a nephew in NC State. Anyway, what's the highest basketball court in the land? If we're in person, I'd give away a candy bar or something to keep you all interested. Highest basketball court in the land is located.
Probably, it must be in Denver.
Denver, not Denver. All my questions are trick questions. The U.S. Supreme Court, the highest court in the land. Above the chamber, there's a basketball gym, and I made 2 shots. I'm 2 for 2. So the highest basketball court is in D.C. This was my mentor, Morris Rosen. He passed about 10 years ago. Both Jamie and I worked for him. Very much a Southern gentleman. Treated everyone with great respect, whether it was a judge or the janitor. We learned from him. And we do trainings, crisis intervention training with local police and sheriff's office. And I always highlight the fact that they need to get a mentor. We all need a mentor in whatever field we are, and also try to help somebody by mentoring an individual. This picture of my mom, she passed about 3 years ago. I've shown this picture just to make sure we always need to have somebody advocating for us. A year before this, she was in the hospital, and the hospitalist doctor said, it's time to let her pass. No, we said her mind is very alert. We got to get the back pain in check, and we brought in someone from the outside, gave an epidural. She lived another year, and she was able to make it to her grandson's wedding here in the same church that she was married. So always want to have somebody advocating for us and our seniors. Estate planning. We don't want your will to look like this, even though this is an acceptable will. We deleted the names on there. A will in South Carolina has to be in writing. It needs to have 2 witnesses, which this will did. We never know when God's going to call us. That's kind of my list over there on the right, going to the grocery store. And then you never know when you're going to pass. So very important that you get with your attorney and do proper estate planning and do a will. To make a will in South Carolina, you have to have testamentary capacity, basically a 3-part test. Know the objects of your affection, your family, your friends. Generally know what you own, not very specific, but generally know what you own. And then 3rd, knowing who you want to leave it to. Here's a little checklist of 11 documents, 11 things to consider. First is an estate planning checklist. Attorneys will give you those. We sent you an example of some. A checklist is very important to list all of your assets and your family members. We want to learn a few concepts this morning. One is the concept of probate assets and non-probate assets. Probate assets are those that are controlled by the will, or if we don't have a will, the intestacy statute. State legislature has written us a will for those that don't have a will. Non-probate assets are those that are controlled by third-party contracts. We think of those as, say, life insurance, where we designate a beneficiary, a joint account with right of survivorship. A lot of times real estate nowadays is joint with right of survivorship. The point here is that there's a number of ways that we can transfer our property to our loved ones, to who we want to get it to, and just need to know to look at the ownership. Very important when you're doing your estate planning to go ahead and pull out your source documents, get the original, and see exactly how the property is owned. Many times we think it's owned one way, and then we find out it's a different way. Number 2 there, and number 6, we always want to have a will, and we always want to have a trust. The question for you is whether you put the trust inside the will, or whether you create a revocable living trust, and then the attorney will also have you do what's called a pour-over will, in case you miss putting something in your living trust. That will capture that and pour it over into your established revocable living trust. Most South Carolinians are fine with a trust inside a will, and the will probating in South Carolina is not that expensive. It's $95 on the first $100,000 of probate assets. Does not include the non-probate assets. So it can be less expensive to just do a trust inside a will. If you own property in a number of different counties, number of different states, then it may be advisable to do the revocable living trust. But I'd have you sit down with your attorney and figure out what's best for you in your family situation. A trust basically is just a separate entity like a corporation, partnership. The person in charge is called the trustee, and then you can decide when the beneficiary receives the assets. Maybe it's, what we recommend is maybe 1/3 at 25, 1/3 at 30, 1/3 at 35, so that they learn along the way. I saw one where the child couldn't get the money until age 65. Thought they're a little restrictive, but I think they wanted to make sure Social Security was in play, that they weren't out on the street. Anyway, a will, the person in charge of the will is called a personal representative. Used to be called executor, executrix. You can still use those terms. In South Carolina, you can have a will where you reference a written memorandum concerning personal property, such as say your golf clubs, your jewelry. That way you don't have to go back to the attorney each time you're changing who receives an item of personal property. Again, you can reference that in your will and then change that written memorandum as you see fit. In that written memorandum, just make sure you describe the property, the personal property, well enough so that a third party would understand what you're talking about. Number 3 there is a financial or business or durable power of attorney. This allows me to appoint my wife to pay the bills if I become incapacitated. I think I've had about 15 kidney stones, so she can pay the bills if I'm incapacitated. A power of attorney really just allows the person to act based on the powers you give them. It's a very useful tool, but it's also very dangerous because it's not being regulated. So you just got to watch who you give a power of attorney to, because they can do with your assets as if they were theirs, but they are under a fiduciary duty. The financial business durable power of attorney is the one document that has to be recorded, and it's recorded at the Register of Deeds office here in South Carolina before it becomes effective. It's called durable because if a person becomes incapacitated under strict agency law, if the principal is incapacitated, then the agent cannot act for him. And that's generally when you want somebody to act for you. So it changes that presumption and it allows the agent to still act for a principal, even if the principal is incapacitated. Similarly, we've got another document called a healthcare power of attorney. In South Carolina, that's a statutory document right out of our code of law. So it's the same for everybody in any of the 46 counties you may be in. The beauty of the document being the same form document is that the healthcare worker, the doctor, the nurse, the EMS worker, they'll say the same form each time. Even though it's a statutory or form document, it has great flexibility. I know Jamie sent out these documents to you. Take a look at that, and you will see that you can put it in your own words. You can make it very restrictive. You can just grant discretion to your agent. There's a lot of choices in there. Even relates to HIPAA requirements and organ donation. So take a look at the healthcare power of attorney. It does not have to be recorded. It's advisable to provide that to your primary care physician. Number 5 there, the declaration of desire for natural death, also known as a living will. It gets confused with the living trust. The living trust deals with property. The living will deals with end-of-life decision-making. It came about as a young lady named Nancy Cruzan. She was involved in an automobile accident out in the Midwest. She ended up in a ditch. Ditch had water. She did not have oxygen to her brain. She was in a vegetative state. She had indicated prior to that verbally that she didn't want to be kept alive in such a condition. Hospitals and businesses of keeping us all alive went all the way up to the U.S. Supreme Court. They said you can withdraw the life support, but the declaration needs to be in writing, can't be verbal. So that's why we have the living will. And keep in mind, 2 doctors need to sign off on that. We have another document, another advance directive known as the 5 Wishes. This came out of Florida. The Aging with Dignity organization there out of Tallahassee, Florida. You can Google the 5 Wishes and you can download their document for $5. And it allows you to put it in your own words, with how you desire to be treated. It's sort of a combination healthcare power of attorney, living will, and almost a DNR. They overlap. The main thing you need to look at in doing any of these advanced directives is make sure you're consistent in your selections. Don't say maximum treatment on one and then withdrawal treatment on the other. The DNR, do not resuscitate order. My brother had this. I lost him to cancer about 8 years ago. He knew he was going to pass. He knew it was a matter of days. With the doctor, they had a DNR. In the event that he had a heart attack, he could go ahead and pass, end his suffering, and end his the family suffering. All tough decisions that we have to make, all that are very helpful to your family members that may have to make those decisions once you become incapacitated and sick. So we can take that burden off of our family by making these declarations. Work with your attorney because some of these documents overlap and then some cancel out the others. Just want to make sure that your wishes are carried out. Similarly, we've got this physician's order for life-sustaining treatment. In some states, it's called a medical order for life-sustaining treatment. Again, it's a combination, living will, 5 Wishes, DNR. It's being piloted here in Charleston over at the Roper St. Francis Cancer Unit. Again, it allows us to make decisions in that regard. These decisions have moved from, say, the doctor's office to the lawyer's office, but generally you always will rely on your doctor to help you navigate these end-of-life issues. I know they're not easy, but it's one way to take that burden off your family having to make that decision. Organ donation, we've got the South Carolina gift of life. We can do it on our driver's license. We can do it on our healthcare power of attorney. A number of places that you can do it, and also in your 5 Wishes. The safe cremation law. We had Michael Jordan. His dad was killed, James Jordan, in North Carolina. His body was dumped in a rural county in South Carolina. They didn't have space to keep his body. His body was decomposing. I think they kept his jaw and his hands, and then realized 2 weeks later that they had cremated the body of James Jordan, Michael Jordan's dad. Our state and many states stepped in and passed the safe cremation law. If you're choosing cremation, and more people are, I talked to the funeral home directors, and it's up to 60 or 70% of their business. You need to do a pre-need authorization with your funeral home director or get with your attorney and go ahead and put it in your estate planning documents. Cremation is less expensive. It's got some advantages to it. And also defining a funeral today, talking to us funeral home directors, it can vary. You can have a wake with an open casket and then have a cremation and then a memorial service. So we all need to decide. The 2 certainties in life are death and taxes. And that's one reason the group out of Florida started that Aging with Dignity, to get Americans talking about death and dying. Ran across this plane. This guy was flying in from Maine. He says, being cremated is my last hope for a smoking hot body. I don't know, try to make you smile. And here's another one. This guy. Anyway. Y'all can send me an email. Tell me if I need to pull some of these. They're pretty bad. We're trying to make you smile here today. I don't know. What are the 2 rules? Who's been in a courtroom? Two rules in the courtroom as far as jokes. What's it? Any speeders here? Who's been in the courtroom? Two rules about jokes. Only the judge makes them. And which rule two?
Everybody laughs.
And everybody laughs, no matter how bad they are. Anyway, that's my British humor there. If you've been to Charleston, down at the Dock Street Theater, it's on Church Street. Our office used to be right on Church Street. I was leaving there late one night about 30 years ago, crossing the street, knew to look to my right because it was a one-way street. Lo and behold, there's a car coming the other way. It almost hit me. And I waved to the man in the back, and we've been friends ever since. Who was that? King Charles. So that's about as close as I got to royalty. He about hit me. I probably should let him hit me, and then I might have been at his coronation. If you want to help others, every community is blessed with a community foundation. Ours is called the Coastal Community Foundation. They just celebrated their 50th year in business, and they take the administrative cost off a family member trying to help others. We had a devise here that was about $50,000 to help Charleston County high school go to college. They looked at setting up their own foundation, getting it qualified with the IRS, South Carolina Tax Commission, having a tax attorney, CPA. They're going to use up most of that $50,000 at no cost. They could simply go to the Coastal Community Foundation and set up that self-directed charitable gift. One of the gifts they started with was the Center for Heirs Property. It's located now in North Charleston on Rivers Avenue. They can be very helpful. They do wills clinics. The late Reverend Clemente Pinckney was instrumental in getting the right of first refusal to help other heirs hold on to their property and not for a real estate developer to take advantage of them. Again, their next will clinic is up in Ladson, you'll see there. And they also do wills, I believe, on Thursdays. Call ahead. I think it's like $50 to get a will if you qualify under their income requirements. In selecting an attorney, one of the better ways to do it is Martindale Hubbell. Again, we talk to friends and family and selecting doctors and dentists. Do the same here. If you want an independent look at, you can go to martindale.com, list all the attorneys around the country, list them by location, list them by their areas of practice, their expertise, their academic credentials, and then it also lists a peer rating, A being the highest. Again, martindale.com. South Carolina Bar also has a lawyer referral service. If you cannot afford an attorney, we have Charleston Pro Bono Legal Services. You'll see the income limits down there on the bottom right. They are there to help all of our citizens. We also have South Carolina Legal Services that helps those statewide, and they also do free will clinics. In between, if you don't qualify for one of those, but can't afford the full rate, we have Charleston Legal Access, and they help based on a lower hourly rate, you can see there. The ABA is very pushing mediation. All courts try to have mediation, and rather than having people litigate, we have people work together and try to resolve issues before a family member takes a stand and further disrupts the family. For those that in the military, remember this free military legal assistance at military.com. And if we're in person, we've got coins from our Veterans Treatment Court that I would give to any of our military on today. We appreciate your service. Organ donation, you can see there's a lot of people waiting for organ transplants. The late Dr. McManus started Donate Life in South Carolina. Number of forms there, number of educational tools to help you there. Sharing Hope is another organization located west of the Ashley that helps with organ donation. Those that have been to Italy, this California family lost their son there. Italy did not have an organ donation plan. They donated his body and changed the culture there. So it's called the Nicholas Effect in honor of the 7-year-old California boy that gave his body for organ donation. Elder law, let me just touch on a few things here. As we all age, we're looking at a number of things. If anybody on here is young, that long-term care insurance can be very helpful and affordable when you're younger. In South Carolina, in Charleston, we have the Palmetto Project. You can see the number there. They can give you free advice. They're located on Rivers Avenue in the Trident building there. And they'll also, if you call them, they'll come out to your house and visit and try to advise you also. Again, another excellent free service. We also have the Trident Area Agency on Aging. If you're caring for a family member, their family caregiver support program can be very helpful. They can give you a break and take care of your loved one while you get that break. We also have the Department on Aging. We have some restructuring going in state government. But at one time we got Connie Munn, who's director of the South Carolina Department on Aging. They also have a number of good free resources. If you can't afford a bank as a trustee or don't have an individual as a trustee, Family Services, a local nonprofit funded partially by the United Way, can help. They do business as Origin. Many of our banks don't want to be the trustee unless the amount in the trust is over $1 million. Family Services will service those that the banks will not pick up. Again, we have for our veterans, a VA caregiver support line, and they can also assist you. We got the Ralph Johnson Hospital and also the facility up there on Rivers Avenue. This is one I ran off. This was started in, I believe, in North Carolina. Care Yaya meaning grandmother in Greek. They've trained some College of Charleston students. So if you want to have help that has been had a background check and vetted for, I guess, nominal hourly rate, they'll come out and help you care for your loved one. And we always want everybody to take a ski vacation. Any skiers here? Like Lindsay Vaughn's making a comeback, isn't she? Any skiers? What we mean by ski vacation, we tell people to spend the kid's inheritance. You never know when you're going to pass. Enjoy it. It may not be taking a trip. It may be helping somebody with college, with a new car, with a wedding, with buying their first home. And if the kids aren't nice to you, you can always leave it to your dog or your cat. Last 3 or 4 years, we recognized Pet Trust in South Carolina. We had 2 dogs in Charleston County get $900,000 in trust. Couldn't be kept outside on a chain. Any surgery, I think, was down to Auburn University. And that out on Kiowa, one of our barrier islands, a dog out there received a home. So I always tell the high schoolers and college people to be nice to their parents. Otherwise, they're going to leave it to the dog or the cat. Wills, Probate, and Estate Administration. Let me just touch on this. In South Carolina, we have a version of the Uniform Probate Code. There's 3 ways basically to probate it. If it's under $25,000, and we're talking about probate assets, no real estate, you can do a summary proceeding. Our typical probate is normal administration. We have to give notice administratively to what we call interested persons. Interested persons include those people named in a will called devisees, those that would take, if there's not a will, called heirs, and then we have to give notice to creditors, which we do by newspaper publication. So it takes 9 or 10 months to probate the estate because our creditors period for a newspaper publication runs the first time it's published and runs for 8 months. Contested cases, locally and nationally, we have fewer contested cases. The kids aren't waiting until mom or dad pass. We have battles in the trust, the powers of attorney, the joint account. So anyway, you can start with a summary proceeding and realize you have real estate, move to normal administration, and then end up having a contested case. And as far as heirs property, we have charts that can show your family tree. And I've done some genealogy, and boy, when you start going the other way, it gets exponential. So, but we do have charts if you need to help with heirs property. What's a laughing heir? I've looked 30 some years for a laughing heir. I finally found one. we all want to raise our hand and be a laughing heir. This is somebody that has a family member pass that they didn't know, never met, never saw him, and lo and behold, you got a check. This individual, Mount Pleasant, got a check for $47,000. He thought it was a scam. He called the attorney. Attorney said, no, it's not a scam. He then asked the attorney, when's the next check coming? So I think he's up to about 80,000. So never met this family member. The person had an estate of about 5 million and didn't do a will. So they had to track down the different heirs around the country. Then and now, as far as probating an estate, you used to have to come in person. We still accept you in person, but we also do e-filing. And we're now open 24/7, and you can do electronic filing. You can see we're good anywhere in the world except where? North Korea, and we're working on North Korea. And Jamie's got Dennis Rodman trying to get Kim Jong-un. I don't know, trying to entertain you. Anyway, our easy filing, it's a one-time $7 fee to our Atlanta-based company that does our easy filing. You can file as many documents as you want. You can file 1,000 documents for that one-time fee. By the time you consider postage or coming down to pay to park, I think you'll find that easy filing is very helpful to our family members. And you can do it at any of our local libraries. As a side note, I'd say visit our local libraries. They've all been beautifully renovated and restored, very high tech. Again, our county is about 100 miles long, stretching down from Edisto all the way up to McClellanville. And there's a number of different libraries. Here I am over in North Charleston, visiting the Otranto Library and showing you that and even I can probate an estate electronically. The copier acts as a scanner, and you can scan the documents right down to us. Another thing that I'd highlight, I'm amazed at how many people find unclaimed funds with our state treasurer. You can go online, you can look up your name, look up the name of other loved ones. You'll be surprised. Apartments, different companies that have deposits, insurance companies, if they have a sum of money, instead of trying to track it down to you, they'll shoot it over to the treasurer's office. And then on the treasurer's office website, you can take a look at that. It'll tell you whether it's over $100 or under $100. To file and get your money, you can all do it electronically, just scanning in some documents. Trust and estates, what are we seeing in Charleston County? We had a tragedy. We lost a Charleston 9 years ago. I grew up with Billy and Randy Hutchinson over there on the playground. We found among them that most first responders did not want to do a will because they thought it was bad luck. And so we've tried to change that mindset and help them get wills because they're the ones running into the burning buildings and we're running out. Uh-oh, freezing up on me. Any questions so far as I've let me look in the chat, maybe a question there. Yeah, good. Jamie, are you there? It seems like it has just jammed on me.
Oh, yes, sir. I'm here. It may be that you may want to end the slideshow and then
Yeah.
get back to it and see
No.
if it may resume.
Oh, there we go.
Oh, thank goodness.
Okay. We also have a tragedy where the Emmanuel 9 were murdered. Charleston showed that love conquers hate. We had no violence. The late Reverend Clemente Pinckney is in the middle there. He was instrumental in getting that right of first refusal for our heirs. So before an heir can sell to a developer, the other heirs have a right to buy. Football players are going on. Packers lost last night. Clay Matthews, senior, was a boxing coach at the Citadel. They had to reform their trust and will. My son's always trying to collect autographs. I told them they needed my autograph and got all their autographs on the form. So the late Henry Pickard won the Masters a long time ago. Very important. We can learn here to always tell our attorney everything in the family. He did not tell his lawyer that there was a predeceased son. The son died coming to see him play in a golf tournament. That reformed the will and trust so that the children of the predeceased son also received a share. If you're a famous person, Shoeless Joe Jackson allegedly threw a World Series. His will was filed in Greenville County. He didn't sign many documents. He did sign his will to baseball collectors worth about $75,000. So they sued. The residuary beneficiary sued the probate judge to get the original back. He didn't care one way or other. Went up to the state Supreme Court. They said, no, the original stays with the court. The countess that started Spoleto, very large estate, used a local attorney. She may have selected him through that Martindale Hubble resource. James Brown over in Aiken named his trust the I Feel Good Trust. So whatever you like to name your trust, you can. Marriage license, I'll just touch on this. If I'm going to get married, we program this Love, which is live online virtual marriage application. And we do about 7,000 marriage licenses a year. And about 2,000 of those are outside our county. It did not like. All right, Jamie, we jammed again. It's let me play with it. Any questions on estate planning, estate administration, anything I can help you with today as I play with this and try to get it to go forward?
Well, I have one. My aunt has a will. She does not have a trust. And in her will, she has put all of her belongings, including a condo, which has a mortgage on it. And she has thus far refused to consider putting the condo in a trust or joint ownership. So I'm just wondering, when she does pass, what I'm the beneficiary, what I can expect to do with this condo with a mortgage. What should I be prepared for?
Okay. Let me make one point. It may be good that the property stays in your aunt's name. The one time the federal government is good to us is at death. They give us what's called a free step up in basis. Let me try to explain that. If I had should have bought a lot of property in Charleston a long time ago, but if I had bought, say, a piece of property for $10,000, and today it's worth $100,000, if I sell it for the $100,000 while I'm alive, I deduct my basis of $10,000. I have an income gain of $90,000 that I have to report on income tax. If it goes through my estate, say I die today, and my wife sells it a day after I die for the $100,000, she gets a free step up in basis to the fair market value at my date of death. So if she could sell it for the 100, her new basis would be my fair market value at date of death, which would be 100. She'd have no gain. So sometimes it's good. I'm not sure if that condo is appreciated, but it may be good that it stays in her name. And if I'm advising the senior, I generally tell them to keep it in their name. They may need to pay, some bills, or they may need it themselves. A lot of times you can talk to various attorneys. Sometimes the home is not always the best asset to put into a trust. So the way she has it may be okay, but I'd have you sit down with an attorney and look at the options. But if she doesn't want to change anything, it's, that's her call. Yeah. Does that help? Yeah.
Yeah, I understand all that. I'm just wondering, when she does die, do you have any idea what I should expect regarding how long it would take to, I see probate takes 9 or 10 months. I'm assuming that I couldn't sell the condo until it's through probate.
Good question. Generally, it's not tied up in probate. We'd look at the will. After a person has passed, you can open the probate If the will has a power to sell clause in there, then you can go ahead and list it for sale. Or you can petition the court if it doesn't have a power to sell, and you can sell it prior to that creditor's period expiring. So you can sell it a day after someone has passed, theoretically. The buyer, on the other hand, may ask you or require you to keep the proceeds or some of the proceeds in an escrow account until that creditor's period expires. Also, even if you have a power to sell clause in the will allowing you to sell it without court approval, many buyers and title insurance companies still want you to go to probate court and get the power to sell, just to protect themselves. So from a practical standpoint, sometimes the business side runs that more than the legal side where you have the power to sell. So I would check her will, see who she names as personal representative or executor, executrix, and see which powers are in there. And then see who she left it to. And then normally a buyer is going to want the estate to sign off. If there's people named in there that take the condo, they may want them to sign off too. So even though you have that power to sell clause, which we recommend in all wills, from a practical standpoint, the title insurance company may still require the court approval. Does that help? Yeah. Okay. And then we have a
Yeah,
whole
thank you.
thing that I can walk you through, the probating of an estate, which comes after this.
Thank you.
Okay, I'll run through the marriage. I didn't like to tell you I do. Some of these things. These are people coming to Charleston to get married. We're very much, and you can see the number of people coming. All right. Sorry, it's jamming today. Must be Monday. Doesn't want to help today. It'll go back and then forward. Jamie, you have any thoughts? Get out and come back in, huh?
No,
Man,
I'm
I
so
love our
sorry.
signage. No, it's good. Look at our signage here at the county. We got marriage license division. On the right, we got commitment division. So everything is good. And I'll just talk about civil commitment. Again, we want people to get help voluntarily. If they won't go voluntary, then we have a process for them to get help. And drugs and alcohol, mental illness affects all of our families. We're just trying to get people the help they need. And we do it at the various hospitals, and we do a lot of them virtually, which has been very helpful, not to have to transport our citizens to the courthouse. We can do them informally. Well, okay. Any other questions we have as I try to?
I have a question.
Yeah.
It's an estate had all liquid assets payable on POD that transferred to a designated heir. And there was a condominium with a mortgage. So there was no money to pay the mortgage payment. What would the executor be responsible for in that case?
Okay. First off, the executor is never responsible personally for any debt unless they mismanage the estate. They're not responsible for the debt. In that case there, generally we look at the will. Generally the taker, the person receiving the will, the condo, takes it subject to the mortgage, but we'd want to read the will. The will, sometimes they'll say pay off the mortgage, but that's rare, but it's probably take it subject to the mortgage. If there's no, is there any equity in the condo?
Yes.
Okay. So it's worth hanging on to. And, somebody could make a loan to the estate to pay the mortgage payments. And I'm not sure who's taking the accounts versus who's taking the condo. Is it different?
All the same heir.
All the same people, then they can all work together, put money in the estate until the condo is sold. Yeah. I mean, and just document what somebody is paying.
Basically, they just assume that mortgage then.
Right. Well, the mortgage is not assumed individually, but it's, the property is subject to the mortgage.
Okay.
So they can't do anything until that mortgage is paid off. If you talk to most lenders, if someone has passed, they will work with you, if you're looking to sell the condo. So if hopefully we don't get late behind the payments, but they generally will work with you. They don't want to own the condo. They want, to get their mortgage paid off. So they generally will work with you.
Okay, thank you.
That help?
Yes.
Okay. For our veterans, we got the Ralph Johnson Medical Center. We've got a new facility in Berkeley County. I was hoping. Jamie, it's a lot like life. It goes one forward, two back, or two back, one forward.
Judge, I texted you what I had seen on line to remedy it ideally.
Okay.
What keys to click on to.
Okay. You want me to
I'm gonna read it to you.
do you like my TV and hit it? No.
It's asking you to click on, the Alt plus the F4 key on your Windows, of course, with Windows, Alt.
Okay.
4. Yes, sir.
You'll see the Wake Up Carolina. This organization has started fentanyl. We're losing too many people to overdose. They give fentanyl training locally. It's not just for illegal drug users. It's also for our seniors. I know my mom had a pill reminder kit, and sometimes that can get the pills in there can get mixed up. And so it's very important that even for our seniors, that we do have Narcan and be trained on it. Uh-oh. I mean, I think it went all the way to the beginning, didn't it, Jamie?
That might be a good thing because maybe just to restart it, maybe
That's
it'll.
come up. You're probably right. Let me just show y'all. Uh-oh, and it wants to go from the beginning.
Yeah, it always, I'm so sorry. It always starts the first slide when you click on slideshow. There
Okay,
was no way to avoid that. It always does that.
okay. Let me try this again. Alt 4. Yeah, but it's gonna go from the beginning, isn't it?
Always defaults, no matter what slide you click on, it always just goes to the first one, I'm afraid.
Okay. Can y'all see the slides on the left? That might be the best thing to do. Because I think we have more questions concerning probating the estate.
We see them, they're just, of course, a little smaller.
Okay. Let me, how about from current slide? Nope, that might do it. Let's see. Anyway, we've got some problem-solving courts that we started. Hopefully people get help voluntarily. If not, we have the involuntary process, civil commitment. If not, we've got like a drug court to give people a second chance. Judge Goldstein was a Brooklyn cop turned lawyer turned judge. He actually came to Charleston to help us start our drug court. Maybe it's not wanting to move at all. And we got a mental health court. I went out to Seattle, brought that back. They had a civil commitment patient kill an off-duty fireman at a Mariners baseball game. So we use the same tools of drug court. on those with mental health court to help. And for our veterans, we started the veterans. Anyway, these are our problem-solving courts. And we'll go forward. And let me see if I can't get to the typical file and show you there. We do a commencement for our drug court here. Brian, not always the smartest when you're on drugs and alcohol, he broke into the chief of police home, Chief Mullen. Hopefully the chief was not home. Brian survived, and here he is paying restitution back. On the far left there, you'll see Judge, federal court Judge Brucey Hendricks joined us that day and started a federal drug court and also an opioid task force. Other questions you may have? You know, we keep track on a dashboard of overdoses, and they can tell if overdoses are occurring in a certain area. Conservatorship, guardianship, we touched on this. We want to avoid conservatorship by the use of business power of attorney or a trust, and avoid guardianship by the use of a healthcare power of attorney. Again, probate court has jurisdiction over adult guardianships, family court over minors. We give the person the greatest independence that they can have under guardianship. We're always trying to go for limited guardianship. Again, we've got about 1,000 of these cases open. We'd like to have none if people could do their estate planning with a healthcare power of attorney. And if we take all the rights away, it would be a plenary guardianship. And conservator, again, is of the money. Use of a trust or that business power of attorney avoids that. And we do have to keep up on these. We use bonds, which is an insurance policy to make sure the conservator keeps the money intact. We also have a visitors program. If you have a family member under guardianship, we train law students. We were selected with Maricopa County, and we train law students to go in teams of 2 to check on our seniors. And of course it wants to stop right there. Jamie, when I did that Alt-4, it just took me all the way back to the beginning. Yeah.
I see. I'm gonna explore further to see what
Okay.
the other alternatives are. It says R2 command. Oh, no, never mind. That's if you have a Mac.
Okay.
It says worst case scenario, if it doesn't start, work to restart your computer, but that sounds too much.
Yeah, I'd lose everybody here.
Yes, sir.
It's moving a little bit, so let me just see.
I'm so sorry, Judge.
Other things that I would mention, you know, as far as probating an estate is there's a timeline. After a person has passed, within 30 days, you're supposed to deliver the will to the court. Once you're appointed, you have 30 days to send out what we call information to heirs and devisees. And that's to everybody, people named in the will or people who would take if there was not a will. We also have to file an inventory and appraisement within 90 days. Again, the probate's going to take 9 or 10 months, and we try to assist people as best we can through different workshops. Another thing that I've mentioned for those in Charleston County or anywhere, we've got smart911.com, free service. We can put our information in there. So when EMS is coming, they'll have background information on our medical needs, any medication we may be taking, next of kin, what to expect when they get to your home. Again, the estate administration workshop, you'll see that we've got some recorded, and I'm happy to, computer, if it helps me, we'll run through typical estate administration. These are our workshop videos. So if you want to hear the same bad jokes, you can watch it again. But no, if you want to, we have many people that watch the detailed estate administration one and come back to that while they're going through the process. Maybe they look at the first part as far as the opening estate, and then 90 days in, when they're looking at the inventory, they come back and review the video then to see exactly what their duties are. And here's some of my ski trips to try to, my son doesn't realize I'm spending his money, his inheritance. And we've had, trying to take one trip a year. Remember? It's still jamming on me, Jamie, but I'll figure out something here.
Go ahead and eat breakfast.
Yeah. And my dad was in the Army, in the military today. Went down to Panama to see it. I was amazed at, if you look at the top left, very wealthy country. About 30% of the ships coming into Charleston go through the Panama Canal. The toll to go through is $1 million to $1.3 million. They generate about $5 billion in fees, so very wealthy county. And over the holidays, we went to Italy, finally made it to there. So, and my wife's been wanting to get there. And I thought Charleston had some old buildings. They're all new compared to everything in Italy. It's just amazing. Let's look at a sample estate file. Again, we have 3 ways to probate an estate. And if I can assist you here, again, the summary proceeding, you wait 30 days. You can open and close the estate by using an affidavit. And sometimes we have people with large estates who have revocable trust. And then lo and behold, there's one asset, a car or a boat that they did not put in that trust. They come along and do the summary proceeding. Again, the majority of our cases is normal administration. The background there is you're just giving notice, and if no one objects, the court never gets involved. We look and see to make sure that you've given notice. You'll file a proof of delivery or affidavit that you sent notice to interested persons, the heirs and devisees, that you did the creditor's notice. You file the inventory and appraisement. And at the end, basically 3 ways to close the estate. If it's a sole heir, sole devisee, you can simply just do a verified statement. The family members can get together and waive the closing documents as the second way, or you can send out the closing documents, which basically is saying, this is what I've done. Here's the accounting, my proposal for distribution, and a notice of your right to demand a hearing. Most of our states, 95% of them go through without any issues. Again, our contested cases are fewer cases, but that's where we have notice and hearing each step of the way. Here's a typical estate index file, and we'll send this out to you. We start with a death certificate, go all the way down to the certificate of discharge. If we have a body, then we have a death certificate. If we cannot locate a body, then if we have an accident, we'll take court testimony. We had 2 boys drowned on Folly Beach. They found the body of one, not the other. We had a sailor that hit the jetties, didn't find his body. And then we had a small plane crash off the coast. So we took reports of the Coast Guard and the FAA, and we can declare that person deceased. Also, if a person goes missing, now if they're gone missing for 5 years, that person can be declared deceased. We had somebody hop on a plane from Charleston, go to Atlantic City, never heard from, one of those unsolved murders. Family members came in and testified that, yeah, every Mother's Day, Christmas, birthdays, he always did something. And so we stepped in and did that. Here's a typical death certificate. Again, if you have a cause of death that you don't want to disclose on the public record, maybe it's substance use disorder, maybe it's suicide, most courts will take the top part of the death certificate. If you die with a will, it's called dying testate. Again, if you die without a will, it's an intestacy. And that way we look at the state statute. State statute generally provides the order of distribution. If there's only a surviving spouse gets all of it. If there's surviving spouse and children, surviving spouse gets 50, and the child or children share the other 50%. And we'll go through looking at the will. Let me see while I'm here. And you'll see this will right there, there actually was a trust for somebody under the age of 25. So trust can be very simple inside a will. It can be a provision or a paragraph or a whole page. Of course, it's jamming on me again. There you'll see in item 10, just a very simple trust. So if a child was under the age of 25, they would get it then. Again, under conservatorship, a child's entitled to the money at age 18. And we have many that people die intestate and they come and get their money at age 18. And we always worry whether they can handle it or not. Again, we would recommend, say, 1/3 at 25, 1/3 at 30, 1/3 at 35. You open the estate by this application, and it just has information, 6 pages long. It'll have information on the decedent. All of our probate forms have great flexibility. If you look at this one, you'll see on the left there, about a quarter of the way down, we've got application. That means it's an informal process. If we're going to have notice and hearing, we'd select the right side, which is the petition. Again, information there. The one area where we give notice, an example I have here, I have dad passing, survived by mom and 4 kids. 2 of the kids take under the will, so they would be listed under 4A as devisees. 4B would be the heirs. Sometimes you hear at a cocktail party, I'm an heir under the will. Well, they're not an heir under the will, they're actually a devisee under the will. Heirs are those that take when there is not a will. Anyway, 4A and 4B, we have to give notice to all of them. And I'll show you a form shortly here called Information to Heirs and Devisees. We got people spread across the state, spread across the country, spread across the world. Sometimes they don't know that someone has passed. So that's why we have to give them notice. And generally it's sending the form out that way. Again, you would attach the original will. We're trying to go paperless, but the will has to be in writing. So we may always have just a little bit of paper. Again, for applicants starting the probate, you'll do a verification of the information you provided. For those that are out of state, I would note under this verification, the last part of that sentence indicates you hereby submit to the jurisdiction of this court. So even if you're out of state, you're submitting to the jurisdiction of the court. We'll issue an order of informal probate, an informal appointment if there's a will in the appointment. If you're named as the personal representative, executrix, you don't have to serve, but if you do serve, you have to serve, properly and take care of things. We might remember our parents and grandparents actually coming to the court and being sworn in as executor, executrix. All right, everybody raise their right hand. Let me see if I've got an honest group here today. I got to see the palm of your right hand. Yeah, it looks like we got an honest group here today, Jamie. In the olden days, if you were dishonest, they'd take a red hot poker and send you a mark in the palm of your right hand. I did have a guy take the stand one day. He had a mark in the palm of his right hand. I had to ask him about it. He had a construction accident, he said. So you'll see people taking oaths of office. That's why they raise their right hand. And you look and see if they have a mark there. Once you open the estate, generally $25 to open, and then you select what newspaper you want to publish in. And these are newspaper you can select. The cost varies. The law requires it to be a newspaper of general circulation in the county. It'll be published once a week for 3 consecutive weeks. And the creditor's notice, the period starts 1 year from the first publication. The statute of limitation is 8 months from the first publication or 1 year from date of death. And yes, I do have a bill proposing to do away with the newspaper publication and just do it online because we have that capability. But guess who's blocking us? The
Newspaper.
newspapers, right? So there's no need to, the times have changed. We can put it on our website and we can actually do it statewide, do it by county where people can search. Okay. If you're, the beauty of having a will is bond is not required unless bond states it's required in a will, but I've never seen one. If it's an intestate estate, you may need to post bond, and bond is just an insurance policy that you'll do your job as personal representative. Bond is calculated on the value of the personal property. It's 1.5 times the value of the personal property. It does not include real estate unless the real estate is sold during the administration. So, and again, once you're appointed, you'll be given what's called a certificate of appointment. This is what you can take to the bank, the brokerage houses, to show that you're the person in charge of the estate. Again, the probate code has great flexibility. If you're named as the personal representative and don't want to serve, you can renounce your right to serve and nominate someone else. Of course, you can't skip the person named as the alternate in the will, but you could nominate the alternate, or the alternate can also renounce, and y'all could go to a third party. You can also waive bond. Many times we have intestate estates. In the case here, dad dies, 4 kids surviving, mom is the PR. The kids may waive just to save the family the cost of that bond. Here again are fiduciary letters showing that you're the person in charge of the estate. Again, this is the information to heirs and devisees. This is required to be sent out 30 days after your appointment, and you let us know that you sent it out by filing what's called a proof of delivery. The proof of delivery is basically an affidavit. Here, mom is indicating, I sent out the information to heirs and devisees. Keep in mind that 2 of the kids are devisees and 2 are heirs, but we have to think of it logically, give them all notice in case somebody wanted to challenge that will. Somebody challenging the will would be a family member who would take if the will was knocked out. Happens rarely, but that's the basis. Yes.
Do stepchildren qualify if as heirs? My aunt has 2 stepchildren that she's not friendly with, and she has not included them in the will. So is it the personal representative's legal responsibility to let them know as stepchildren?
Generally not, unless those stepchildren had been adopted. They would not take. They would take, I've never seen anything a cheat to the state. They may take if there was no other family members and they were the last ones there, but no, they would not have to be given notice unless they've been adopted or unless they're named in the will. Okay. Again, 90 days after your appointment, you file what's called an inventory and appraisement. You'll see in the left-hand column, non-probate assets, in the right-hand column, probate assets. You only have to list the probate assets. In the example here, I listed both just to show you that many times non-probate is more valuable than the probate. Again, probate assets are controlled by the will or by the intestacy statute. The probate fee to the probate court is only calculated on the probate assets. Again, you'll see inventory and appraisement at the top there. This is the original. Sometimes we have people come back and file an amended one. You can do that by checking the box there. If you look at this form, it mirrors the Internal Revenue Service Form 706, which is the estate tax return. So if you had a taxable estate, you could take the information right out of here and put it into your federal estate tax return. Federal estate tax returns, unless you hit the lottery, most people do not have to worry about it. It's now up to over 13 million per individual. Husband and wife, it's 26 million. So not really an issue. So keep that in mind. With the inventory and appraisement, you'll have supporting schedules, such as real estate. Again, this is real estate owned individually or owned tenants in common. Tenants in common was typical in South Carolina. That's where husband and wife each owned 50% and controlled 50%. More and more nowadays, property is joint with right of survivorship, and that's on Schedule E. Again, real estate can be in a ballpark. Probate fees are on a sliding scale. Pay the extra $6 or $7 for the real estate in the higher end of that ballpark, because when you sell the property, what you put on the inventory and appraisement is going to be your basis. And so, and if you sell it for less, you can come back and amend. If you sell it for more, you can also amend to get that step up in basis. But that's where you work with your CPA and your lawyer to make sure that you have the right value down there. Stocks and bonds, generally we can get that off of from a brokerage account. If it's a closely held business, we have many of those in South Carolina, you may need to do a valuation. There's no requirement to do any valuations for any property listed here. If you had a taxable estate, such as the Countess, then yes, we would do valuation. She had some furniture, some desks were worth $500, some were worth $50,000. They needed a trained eye to tell what was worth what. Schedule C are cash and banks accounts. Life insurance, generally a probate, not generally a non-probate asset, can be a probate asset at times. That generally occurs where the owner of the life insurance policy leaves it to a beneficiary. The beneficiary predeceases the owner, and then the contract says it's payable to the estate. Again, you'll see supporting schedules here. Schedule F, as far as miscellaneous property, just put a ballpark figure down there. Schedule E, again, joint with right of survivorship, does not have to be listed, but can be. You'll see other values there. I'll just point out encumbrances here at the end. You only have to list, such as that condo, you would list the mortgage on that. If she had credit card debt or other debt, unsecured debt, you would not have to list. And then you'll see annuities and retirement accounts, generally a non-probate asset unless it's payable to the estate. Again, that's due 90 days after your appointment. If you get behind on any of this, just send us something in writing. You can do a motion for an extension, a letter, an email. We just need something in writing if you need additional time. After you file the inventory and appraisement, there is a bill will come, and it's payable to the county. And you can see it's $95 on the first $100,000 of probate assets. So probate fees in South Carolina are relatively nominal compared to New York and California.
I have a question here, Judge.
Yes.
When you were going to the back, where we were listing all the schedules, and I was looking at it last night because I need to fill that paperwork. Where it says where my dead person leave the bank account, where his retirement is in the bank account, and I'm the beneficiary there. So I'm not the beneficiary, I was the payable on death. So I don't need to put that retirement on the list. Is that right?
That is
Because-
correct. That's a non-probate asset. You don't have to list it. It's optional if you want to list it, but you don't
Okay,
have to.
and he had an ex-wife, and the ex-wife has already took whatever left in the bank because her name was still attached to the account. So I will write the bank information, but I don't have any contact to her to ask for it. Is it going to be the non-probate money too? It is like a $5,000 or something.
Yeah, generally, if he didn't change that, the presumption is that he wanted to leave it to that other surviving joint tenant or payable on death, whatever instrument he had.
Thank
Unless-
you.
Unless you can show fraud or some other reason, yeah.
Yeah, this helped. Thank you very much.
Okay, sure. Here's the creditor's notice. Again, this is published once a week for 3 consecutive weeks. And go from there. Here's a creditor's claim. Again, we have different colored forms. A good attorney up in the upstate argued that a claim that was filed on a white sheet of paper should be denied because it wasn't on the pink sheet. The Supreme Court said it doesn't matter what color you use. We use different colored forms for the inventory and the application. You can use any color. Anyway, for creditor's claim, if you are the personal representative, you can handle it 3 ways. You generally want to wait till the claims period runs to make sure you've got all the claims and you have enough assets to pay those claims. You don't want to pay early unless you know that you've got enough assets and it's a valid claim. If it is a valid claim, you can pay it. We'll look for some proof of payment. It may be a valid claim, but the amount is off. You can compromise it, or you can think it's not a valid claim. You can send a notice of disallowance or just not pay it and see at the end whether they petition for allowance. Again, we're looking for some type of payment. It could be a canceled check. It could be some type of receipt. If not, we would want you to send a notice of disallowance. And here's a notice of disallowance. Basically, you may say it's not a valid claim. When you send that notice of disallowance, then the claimant has 30 days to petition for allowance. Many times, if his claim is filed, a notice of disallowance is not sent, then sometimes the claimant will wait till the end to see if they're going to get paid. Or they can petition for allowance, such as this form. And then we'll have an order related to the claim, whether it's allowed or not. Again, when you get to the end of the estate, if you have real estate, you'll also file what's called a deed of distribution. Unless the real estate is sold during the estate administration, the deed would indicate who's receiving the property. The deed is a legal document, so our estate clerks cannot complete that for you. We'd have you consult an attorney, or you can try to do it on your own, but we'd recommend getting an attorney to assist you. This is the way the personal representative gives up their right to the real estate. You want to wait until the creditor's period expires before you do that, though. Make sure you don't have any other potential claimants. Again, here's 3 ways to close normal administration. If you're the sole heir, sole devotee, you can file a verified statement to close. If there are other heirs, other devotees, you can do the standard closing documents, which we'll look at shortly. If there's other heirs, other devotees, they can all just waive the closing documents. In many families, the kids will waive if the parent is the, or if another child is the PR. Again, here's a copy of the verified statement. I'm the only heir, only devotee, and I'm filing this verified statement indicating I've paid all the claims. When we get to closing documents, normal way, we would do an accounting. On the accounting, we'd show what we started with, what came in, and what went out. And we detail that. And the other document we would show would be a proposal for distribution, listing out what we have not distributed yet and how we would plan to do that. It was doing so good, Jamie. There we go. Doesn't want to go forward. Anyway, you put the detail. If you have, many transactions, you can, attach a worksheet, an Excel spreadsheet, formal accounting by a CPA. Don't want to go past the screen form here. Questions on the closing documents? Questions?
The regarding advertising, that's a service the court offers.
It's I say we let you pick the newspaper, and then we bundle them together and we get a quantity discount. Before, they always wanted to run that verbiage. If you have any claims at all, it should be filed with the probate court and sent to the PR. We just run that verbiage once and then put all the creditors down there. But yeah, it is a service that we provide. And that's why it's a separate check. You pick which newspaper, they're all good, but they vary in price. You pick which one you want, and then we bundle those and send those to the newspapers. Generally at the end of the week or every other week, we'll send those over. Right. We found that that's better because the citizen gets a cheaper rate. And then we also know that the publication occurs and it takes place. So it's a win-win for both sides. I'm still trying to get them to just eliminate that and put it on our website because times have changed. Yeah. And we can give notice. I mean, the treasurer with the unclaimed assets, he doesn't advertise in the newspaper. He's got it just on his website. Yeah. Anyway, this was a copy of a proposal for distribution. If I haven't distributed something, these are my plans. If I do distribute something, I want somebody to give me a receipt at least, indicating they received something. There's another receipt here, if it'll go forward, a receipt and a release. Many times people won't sign that release because it forever discharges the PR, which is this document here in the middle. And if you wanted to close it, if all the kids got together and just want to waive the closing documents, or all the siblings got together, they waive it, they can do this. That, can save some time and money. They still may look at it in accounting independently, but don't have to require it to be filed at the court. And here, when we're doing the typical probate, we send out a notice of right to demand a hearing, indicating you've got 30 days to come forward. And so this lets you know if you don't come forward, then the estate will be closed administratively. Very rarely do we have a final hearing, but it occurs. You also would file an application for settlement. And then we have a proof of delivery. Again, this is an affidavit saying, yeah, I sent out all the closing documents. You can see here it changes a little bit for mom. She only has to send it to those that were taking under the will. The 2 kids that were not taking under the will do not receive notice. And here's an order closing the estate. If you close the estate, you are fortunate enough to find other stock certificates, you can reopen the estate, and that's called subsequent administration. Again, that does not reopen the creditors period. It just allows you to reopen the estate and deal with those additional assets. And so this is, remember your estate planning and take a ski trip. Other questions, comments? Jamie, what did I miss? Again, if you get behind, we have a tickler system where we send you a nice letter to begin with. Hey, you missed filing inventory and appraisement. Can you please file it? And then we send another letter saying we sent you an earlier letter. Can you please file it? And then the third one is it could be a rule to show cause. And we don't want those because we would have to charge the court fee of $150 to have a hearing. We don't want those. So we're here to help you. I know it's not easy. One of the first estates I probated was my dad when I was in law school with the help of an attorney. So emotionally it can be difficult, and that's where attorneys can help.
Judge, I thought perhaps you want to outline about the young lady with her will and her nephews.
Yeah, it's very important to get with an attorney to do estate planning. We had a client that did their will themselves, or a person came and did their will themselves. They did it about 30 years prior to them passing. They had large bank accounts. To the local nephew that visited, she left her large bank accounts to her least favorite nephew that lived out of state who couldn't visit her. She left some real estate. Well, lo and behold, by the time she passed, she spent down those bank accounts, and the real estate ended up being on water, became very valuable. So her plan of favoring the local nephew did not take place. That's where an attorney could help you, maybe leave 60 or 70% to the local nephew, to the favorite nephew, and 30 or 40% to the other. Stop share. Other questions, comments? Yeah.
Very helpful.
Good to hear that. Yeah, let us know if there's anything we need to add, let us know. Sorry, it's a Monday, my computer was jamming. I just got an update. That's probably why it's jamming. Anytime you get an update, something happens to it.
But Judge, I have a quick question, another one. When my hubby was still alive, he let my daughter, he calls her her daughter too, to rent his house. She was renting and paying money to him. So how am I showing it, in which schedule? And she's continuing, and I'm putting into the probate checking account those checks. So it's accumulating there.
Okay,
And we will continue to do it because they were between themselves. She was allowed to stay there until 2027, actually. They were updating and repairing the house. So is there a way for me to do it?
yes, I think you've got to decide down the road, who gets the real estate, who gets the rental property?
That's the only real estate is she's renting. He had only one house.
Okay, well, my
Mhm.
question is, who did he leave the house to?
Me,
He left it to you, okay. So
yes,
once you deed it out to yourself, she's gonna pay rent to you.
that's correct. But how am I
Okay.
showing that rent on the schedules?
You wouldn't show it on the inventory and appraisement, you just show the property. In the accounting, you would show the rental income.
Oh, okay. Let me
Yeah,
write
in the
that. Thank you
accounting, you'd
very
show
much.
rental income there, yes.
Okay.
Does that make sense? Yeah,
Oh, yeah. Thank you very
okay,
much.
yeah, okay. All right. Well, y'all have a good day. Jamie, anything else? Anything we?
No, sir. Thank you.
Good to see everybody. And you're welcome to join us again. And we also have some of these recorded. So if you can't sleep at night, you can watch us again.
Yeah.
We don't provide popcorn, but it'll be there.
Thank you very
That's
much.
funny.
Very informative. Appreciate it.
Good.
Have a
Thank
blessed
you.
day. All right.
Thank
Thank you,
you.
Judge.
You're welcome. Have a great day.
You too.
Bye now.
Thank you.